I am Sarang Dhote and also the course coordinator of IPR Fundamentals, the protection of innovations. In this lecture, we are going to understand what is the meaning of a patent. This is the third module of this course. So, what is the patent? A patent is a form of intellectual property right that grants the inventor exclusive rights to their inventions, preventing other from making, using, selling, or importing the patented invention without the inventor's permissions. This is the very important. So many times we fail to file our idea in the patent office so that we can found we will found that our idea it become the replications to others. There is a duplications of our works also there. So to prevent these duplications, replications, we must go for our patent filing. This legal protection is granted by a government authority for a specified period, usually 20 hours, 20 years. That means, what if suppose our idea is granted, our patent granted, then this granted applications is valid only for 20 years from the filing date of the patent applications. After 20 years, our idea is now publicly open to all. So this is the very much important to understand the period of our granted patents. Next is what can be patented and what cannot be patented. This is also important. Next, what can be patented? The processes, methods or ways to doing things. The processes we can patent it. Machines, devices with the moving parts or mechanisms, manufactured articles, product that are made or produced, composition of matters, that is a chemical compound or mixtures, improvements of any of the above, enhancement or the modification that makes existing invention is better. Suppose a few years ago, I made a one machine and also I have patent grant for that machine also. But if suppose someone is doing some improvement in that machines, that person will also get the patent because what he did, the enhancement or modifications that in machines that can be also a patent. Next one is what cannot be patented. The abstract idea, concept or the thoughts without a specific applications. If suppose I am sitting here and in the mind I have an idea, but this idea is only a thought. It is not applicable in the daily life. That idea, that abstract idea is not patented. Laws of nature, fundamental principle governing the natural world, that is also non-patentable. Natural phenomena, observable events or the processes occurring in the nature. Next, the mathematical algorithms, pure mathematical formulas or equations are never patented. But use of mathematical algorithms in a particular machines, then this device will be the patentable. This is very important to understand which cannot be patented and which can be patented. Last one is invention contrary to public policy. If suppose any idea is legal or unethical for the public policy, that also not patented. Now, what is the patenting process? How we can go for filing a patent in the various patent office, like in India or in any other countries? There are some basic processes. The first one is invention disclosure. Invention disclosure means what? If suppose you have an idea, first this idea with this idea file provisional specification in the patent office. Okay, this is the first step. Or without going that, you just disclose your idea with the patent office, which is also known as the provisional specifications. After that filing an idea, then go for a patent search to check that it's a novelty. Sometimes we think that our idea is a very novel, but this is not in every cases. We should go for a patent search. During this patent search, we will get some ideas regarding our work, whether it is already published or whether it is granted in any countries. There are the various sources we can do the patent search. We in the later chapters we can discuss what is the meaning of a patent search, how we can go for a patent. This is also important. If suppose our idea, if suppose your idea, it is not a novel, then we are never get a patent certificate, a grant certificate from the patent office. Our idea is rejected. But if suppose our idea is novel after the patent search, we observe that our idea is novel. This is the first idea from the world. So that next procedure is drafting the patent applications. There are the two types of applications. One is the provisional applications and another one is the complete specification. Provisional specification means what? Just disclose your idea. Just disclose your idea and just disclose your idea with the abstract and one background and some forms. But in this case, the drafting of the patent applications, in this case, we start to write claims, diagrams, and what is the idea and what is its background, abstract, actual applications in this case, the drafting of the patent application. The claims is very important, the diagrams, if there is a need of a diagram, the diagram is also important. After the completion of when your draft is ready, then go for a filing of a patent applications with the forms which is applicable for. Okay, this is known as a complete specification. If suppose in the first case you filed provisional specification or provisional form, then we have the 1 year. Remember this thing, we have the 1 year for the filing of the complete specification. After 1 year, our form is abandoned, so that our application is may rejected. So that we have the 1 year from the provisional filing specification. Then after the filing of a complete specification, okay, complete specification, there is a patent examination. Okay, there is a patent examinations. Patent office, there are the patent controllers are there. They are doing the patent examinations of our idea, whether it is applicable, whether you have the industrial value, like that it can be under the patentable category or a non-patentable category. Then after that, next procedure is the publications. Our idea, if suppose the patent examiner is accepted our applications, the next is there is a publication of an idea in the patent journal. Okay, in the patent journal, there are the various types of journal in the world regarding to the patent applications, but in official journals are different. We will see in the next case what is the official journals. In the publications, our idea is published and this journal is for public. Now this is our idea is now publicly open. Remember one thing, our idea is not again is publicly open means what? Our idea is not used another people. Publicly open means what? If suppose someone is already did the same type of work, he or she can take objection on our application, on our application, for our application. So that again there is a opposition period. This one, opposition period is there. If someone takes the oppositions or objections, then again there is a issue for this. If suppose, during the publication, there are the three types of case. First one, there is no objections. If suppose where whatever we filed, what our idea is published and that publications is not having any objection, then our patent is granted. Then our patent is granted. If suppose we have some minute objections for our idea, and we can rectify that objections. After that rectifications, again, our patent is granted. But if suppose the objection is very strong and we cannot rectify it, we cannot clear that objections, there is a strong objections, then our patent is rejected. That our file is, the patent filing process, sorry, a patent application is what? Rejected. Remember this thing. So that there is a opposition period. This is the opposition period. After grant, remember one thing, after grant, our patent, already I told you that this grant certificate is valid only for 20 years. Valid only for what? 20 years. And after 20 years, our patent application is expired. Now our idea is publicly open to all. Our idea is publicly open to all. So this is the patenting process. Invention disclosure, patent search, drafting patent applications, publications, patent examination, filing patent applications, opposition period, grant or rejection, and the last one is the expiry. Remember one thing, whenever we get patent grant certificate from that year, there is some maintenance fee. We have to pay fee for each year to maintain this certificate until 20 years. Remember this thing. Next one is, what is the patent search? Why there is a need of a patent search? Before filing a patent applications, inventor conduct a patent search to determine if their invention is novel and non-obvious. This involves the searching existing patents and publications to identify prior art, ensuring that proposed invention meets the criteria for patentability. That, as I already told you, a comprehensive patent search is crucial for avoiding infringement issues and strengthening the patent applications during the examination process. Infringement means what? If suppose you are doing some work and you think that this is a novel work and you are trying to publish or to get the grant certificate, patent grant certificate from the patent office, during that time, if suppose you are published, so that someone can claim that this is my idea, someone can claim this is my idea, and in that case, the opposition party may file one case against the infringement because you are make a duplication of a work which is already published or already patented. This is known as infringement issues. So to avoid this, there is a need of a patent. Now, next one is, what is the patent publications, which is also very important as a career point of view. When you are a UG or PG students or any faculty, this patent publication is a somewhat very important for a career point of view to strong your resume also. We will see what is the patent publications. The patent publications refers to the act of making a patent application available to the public. As I already told you, available to the public. This typically occurs after a certain period following the filing of the patent application, regardless of whether the patent has been granted or not. This is very important. This term is very important, whether your patent is granted or not. But before that, your patent will get published after after filing of complete specification. Patent publications serve to disseminate the information about a new invention, allowing others to review the details and potentially challenge the patent's validity. So that this is a very important for the patent validity. Next one is, again, the where this our idea is published, which type of journals are there in the globally in the India. In India, the Controller General of Patents, Designs and Trademarks publish patent applications in the official journal of Patent Office, commonly known as the Indian Patent Journal. In the practical session, we actually doing this thing, how to publish our patent idea in patent journal. Another one example of the various patent journals worldwide include the official gazette in the United States, the European Patent Bulletin in the Europe, and the Patent Journal in the South Africa. These journals play a crucial role in promoting transparency and fostering innovations by providing access to valuable technical information and facilitating the exchange idea within the global intellectual property community. This is the main motto of a patent publication. Now, another one thing is, what is the meaning of industrial design and utility patent? The patent comes in the various forms, including the utility patent and the design patent. The utility patent protects the functional aspect of an invention, such as its structure, composition, or method of operations. On the other hand, a design patent protects the ornamental or aesthetic aspect of a product appearance. Understanding the distinction between these two types of patents is essential for inventors to seeking to protect different aspects of their creation. The term protection for industrial design patent in the most jurisdiction is 14 years. That means you will get the certificate after the sanctioning of your design, whether it is industrial design. I am discussing about the industrial design. This is valid only for 14 years. Remember this thing, 14 years. Now, what example? We will see the example of industrial design patent and utility patent. First one example is for industrial design patent is a smartphone design. The industrial design patent could cover the unique ornamental design. This is the phone. The shape, surface is appearance, not the function. Buttons, the curvature of the edges, and the design camera module. This is a patent. This is a regarding the industrial design patent. Here, how to work, what is the processor, what is the working, what is the basic function. It is not in this the case. Industrial design patent only deals with the appearance. Buttons, this is the examples. Then, what is the example for the utility patent? Now, everyone know this is a Tesla automatic car, the self-driving car system. In the utility patent, innovative technology used for the self-driving system. This might include algorithm, that is a software, hardware which is used for the object detection, decision-making process, for the navigation and the integration sensors such as the lidar and camera. This is under the utility patent examples. Now we will see some multiple choice questions. What aspect of an invention does a utility patent primarily protect? The option A, B, C. It's ornamental design, aesthetic appearance, functional features, branding, and marketing elements. Here, aspect of invention, utility. The correct option is C, the functional features and usefulness. What does the patent grant to inventors? Exclusive right to sell invention, exclusive right to make, use, and sell the invention, exclusive right to use invention and personal purpose, exclusive rights to disclose the invention. The correct option is B, exclusive right to make, use, and sell the invention. How long the typical duration of the patent protection? As 20 years. Then, what is the first step of the patenting process? Filing patent applications, conducting patent search, invention conception, licensing the invention. The correct option is C, invention conception. Actual concept or our idea should be there. Okay. Then, what is the purpose of patent search? To determine the market value, to identify the potential licenses, to access the patentability of invention, or to promote the inventions to the public. The correct option is to access the patentability of an invention. Next, what happens if the patent holder fails to meet their disclosure obligations? The patent terms is extended, the patent is invalidated, the patent is transferred to the government, the patent is converted to trademark. Correct option is B, the patent is invalidated. Then, what is the purpose of a patent publication? To keep the invention secret? No. To promote the transparency and facilitate the prior art searches, to limit the access of patented invention, to delay the patent examination. The correct option is B, to promote transparency and facilitate prior art searches. Which is The following is not example of patent journal: Indian Patent Journal, European Patent Bulletin, US PTO gadgets, patent confidentially digest. We know that option D, that is patent confidentiality digest. Now, there are the some filling the blanks question is also there. Patent publication makes patent applications blank available, that is publicly. Then the Indian Patent Office published the patent applications in the official journal of the option is patent office. Remember this. Patent publication facilitated searches for the prior art. Thank you. Thank you. And try to solve the multiple choice questions, filling the blanks questions, which is attached with this. There are the n number of questions. You should go for this. Okay. So thank you.